Hi guys, my name is Kevin. So, as you can tell by the title of the video, I'm a social worker, therapist, and I work in a psych hospital. I work with teens, adolescents, mainly I work with guys. Anyhow, I wanted to share an experience that I had that a lot of my colleagues and just people I work with and people in this field dread. That's going to court. I was actually subpoenaed to court. So a little bit about me. I'm actually new to the field. I'm a baby therapist. I jumped right into the frying pan working in a psych hospital. Very fast pace. Don't have a lot of one-on-one time with patients or clients. It's very on the go, very quick. So that being said, I've been doing that for about 2 years. I've seen a lot of things and gotten a lot of experience in those 2 years. I think one of the biggest things that stood out to me recently is about 4 months ago I was subpoenaed to court. A little bit of background on this case. Obviously I can't go into the details, names, identifiers, things like that. But with a lot of the school shootings going on, a lot more attention has been placed on kids making threats. Like I said, I work with kids, and so there's a kid that came into the hospital and he made some really significant threats to a school in the community, and he had pretty significant access to firearms. And so essentially, without going into too much detail, there's this debate or this discussion on, is this person safe to return to the community? Are they not safe to return to the community now, but maybe later? Or is it just completely off the table for the near future? And so there's a lot of different parties playing into this. There's a lot of different clinical opinions playing into this. There's law enforcement. There's a psychiatrist that I'm working with that's working with a kid. There is children's mental health, basically a health and welfare division for children's mental health services. There's school resource officers. There's a school. There's a lot of different players, and it's very intense. Everyone's very on edge relating to this, and that's one side. The other side is the parents and this kid. So it's really tough. My stake in this was that I felt like this kid needed a little bit more time in treatment outside of the psych hospital where he was at, which we're just there for stabilization and then pass the ball to outpatient or to further residential treatment as soon as possible. So, I continued to maintain that I felt like he needed that further treatment. And so, parents and this kid obviously felt otherwise. They did not want further treatment. So I continued to stand on that platform, and eventually the prosecutor here in my county got involved. They ran with this, and they felt like having my opinion, my clinical impression on this case was warranted. So they asked me to come in first. My employer, the hospital I was working at, basically wouldn't let me do that. They said that it'd require a court order for me to come. I really didn't think they would subpoena me, but I got served papers. I got served papers twice on 2 separate occasions. So I worked with the Ada County prosecutor. He had access to the full medical record, the full chart of this patient, and so a lot of, if you're in this field, you know about HIPAA. Obviously that changes things a lot. Here I am discussing with an outside party everything on this case. So I could go into details. There's definitely some tension with my employer. Some clinicians felt that it was warranted, some maybe not so much. A lot of the social workers, therapists definitely supported kind of where I was coming from. There was only one psychiatrist that thought this kid wasn't an imminent threat, and there was warrants to be made for that. If parents are saying they're going to secure everything, secure firearms, make sure there's no access, probation was going to be involved. There's a case to be made there, so it's not completely far out. So I ended up going to court for the first time, and I honestly didn't say a word. Thought I was going to have to get up and testify. I met with the attorney quite a bit prior. They read the chart. They read my notes in the chart. They read it during court to the defense. Everything was open book. So at that first hearing, the judge felt that yes, further treatment is warranted. Boom. So we start going along with that track. About a month later, the mother appealed, continued to appeal and fight this. I got subpoenaed again. This time, kind of the perfect storm happened. I had to take the stand. I had to testify. And to be honest, I got grilled. I got grilled so bad by the defense attorney, who was good. He was doing his job. I think it was easy for me in the moment to become bitter and frustrated with that. But like I said, the case for this kid to not be in treatment at the time, well, you could have made a case. The other side. And it's up for debate if it was a good case or not, but you could have. So a couple of things, I could go into some of the details on how that process was in the moment. But some of the tips, some of my insight. One of the things I noticed working with the prosecutor is they have their interests first. And that was really, really finicky. That was really thin ice to cross. This prosecutor working for the county was amazing. He was good at his job. He was very professional, very respectful, very courteous, very polite, accommodated me. Met me at times that worked for me to meet with him on this case. But just some of the wording and some of the questions he had, and some of the suggestions he had for me, he came across very, very respectful, like I said. But asking me, would such and such imply that your opinion is this, or would you feel comfortable stating this in front of the court? And constantly, he was just very good. It's hard to word it now, but very good at suggesting things that I should maybe say, trying to get my opinion, get my take at that moment. And what I did is I really kept, it's easy to kind of feed into that, but if you're going to court, you need to rely on your documentation. So I kept everything going back to my documents, back to my notes, back to what I stated, because by the time I was subpoenaed the second time, this kid's been out of the hospital for a month. So even though I felt like this prosecutor was supporting, my cause, what I thought, kind of where I was coming from, I had to be careful not to just start throwing my opinion out places. Everything I said, I tried to reference back to my note or reference back to an event. If I said I felt like I didn't think the kid was safe to be in the, I'm getting grilled by a defense attorney and questioned by the prosecutor at the same time, 2 separate times in this hearing. Okay, if I feel that way, reference what? Okay, going back to, this kid made a statement while he was in class. This is what he said. This is why I feel this way. Or a nurse overheard him saying this, reported to me. This is my take on that. So everything was referenced. So it's really easy. Keep in mind that attorney, especially if you haven't been subpoenaed yet, you don't want to throw your opinion out. You don't want to start throwing HIPAA out the window. You don't want to just, you want to rely on facts. You want to rely on your documentation. So regardless of what they're saying, what the defense is saying, lean on your documentation. Second thing, don't be afraid to make a call. So, in this moment, everything's happening so quick. From when this kid came in to when he left was about 9 days, and it just picked up real quick from there. Over the course of time, the police started getting involved. Everyone started getting involved, wanting to talk to me, the family, whole 9 yards. So, in those moments, I had to make calls, and I had to make decisions, and I had to make choices immediately. Okay, where am I going to go with this? Am I going to stand by my opinion? Am I going to stand by my take? Am I willing to kind of put my risk myself, put my neck out there for this one? And I was. So don't be afraid to make a call. If you feel like you can't make a call in a significant, high profile, intense case, let somebody know. Let the prosecutor know. Let people know. Maybe there's somebody else, or that they can lean on the doctor or someone else. If you feel like you can't do that. That being said, if you feel like you can't make calls, working in an inpatient psych hospital is probably not for you. You have to make judgment calls yourself all the time. Straight out of college, you will be making judgment calls. And ones that could have significant consequences either way. Let's see, next tip. Get comfortable being uncomfortable. So especially the first subpoena I had, there's about a month gap in between the two. It's hard to sleep. It's hard to get comfortable. What's coming up. I really just nothing you do is really going to prepare you for the first time you go to court. Especially me being a new social worker. A lot of people that have been in this profession 15 years haven't gone to court. Some have, a couple of times. So, get comfortable with being uncomfortable, but also really prioritize self-care during this time. Before these hearings, I would take long walks. I took a lot of time just to slow down, time to myself, exercise, the whole 9 yards, do everything right to give yourself the best chance to be at your best when you go into these intense situations. Last to prepare, know your notes well, review your material. For us, we have a whole chart with all the documents in there. I went through, read my notes. I just forgot about the rest of the chart and just pulled out my notes and took those in. I didn't worry about anything else, and honestly, they might ask you, well, the doctor said he was fine at this time, or the nurse said that he was fine at this time, or so-and-so said it was okay, or they thought that he was okay, so what's your thought on that? Focus back to your notes. Don't go outside of the scope of what you're doing. Focus on exactly what you said at the time. Lean on your documentation over and over and over. I can't stress that enough. The defense really tried to get me with, well, the doctor said this, or another clinician said this on this case. What's your stance on that? And I just continue to have to state, I can't speak for them. That's their take. They have the right to their own clinical opinion. But this is mine, and this is why. And this literally went on for an awkward amount of time. This defense attorney asking me the same question, trying to grill me about the same point for what seemed like an eternity up on the stand. So prepare, but also don't over-prepare. If you try to go in and look at your documents and everything, every time somebody asks you something, you have to sit there and shuffle through your notes. You can do that. A lot of people tell you can do that, but I feel like it's just going to stress you out. I started doing that, and I'm just like, okay, this is just not going to work. I know my notes. I know what I said. I'm prepared. I went over this. I went over this with other clinicians, and I was able to answer just smoothly and calmly because I knew my notes. I didn't have to sit there and shuffle through every single one to reference an instance or a site. If it was outside, if I knew it wasn't in there, I didn't respond back to it, and I just deflected. I'm not going to answer something or give an opinion on gray area that I don't have evidence or something to support it with. The last thing, I've already kind of mentioned it, document this. So this stressed the extreme importance, if you're a therapist, a doctor, whatever kind, if you're in this field, even pediatrician, like you get police officers, police officers already know this, but your documentation, I was having my notes at year 2 of being a therapist in a psych hospital read to a judge, 2 judges, attorneys, the prosecutor, the family. Document well. If you document well, that will carry you a long way. I know it can be really difficult, especially if you work in a place or a time where you don't have a lot of time to to yourself or to do these little things or to be extensive. But just I can't stress that enough. The documentation. I did document well. I knew this case was going to be intense from the start, and so everything was documented. It didn't help that I wrote like a kindergartner, and that all of our notes at this hospital I work at are all handwritten. And so that was a bit of a pain, the handwriting, but I did take a lot of notes, and that helped. So especially if you got to allocate resources, but especially if you know something or there's something gives you reason that, okay, this may, for whatever reason, come up later down the road, document well. You should document well all the time, but I get you have to allocate resources. That's just some of my tips. I can give further tips on what it's like being in court, but I don't want to stretch this video out too long. I just knew it'd be helpful to kind of hear at least tidbits of somebody else's take or somebody else's experience on this. I'll probably make a few more videos. I think it's interesting going straight from college. I went to grad school and my bachelor's and master's in social work, and now I've been in the field for 2 years. And just to give a resource to new therapists, new social workers out there, I know I always lean on videos on YouTube, things like that, resources I like to learn from other people. So I'll probably make a few more videos. If you guys have questions, just put it in the comments below. If you think I could have done something better or touched on something else, let me know. I don't care. I know I didn't cover everything in detail. So thank you guys, and I'll catch you later.